Yes, I've been practicing in the areas of estate planning and elder law for 10 years now at Krugliak, Wilkins, Griffiths, and Doherty here in Canton. So today, going to talk about two of those areas, the estate planning and long-term care planning, and some things that, whether you want to call them myths or just some misinformation that can be out there, whether people are looking on the internet because things are different in different states, or they heard something from somebody else that worked really well for that situation, but their situation's a little bit different. So just sort of things that I hear, quite a bit that aren't um, quite right, or are a maybe understanding of the law or the way things actually operate. And wanted to start with the area of trusts that trusts can be confusing and seem very complicated and overwhelming. And there are a lot of things out there on the internet about trusts, and there's different kinds of trusts or different reasons that you might do a trust. And so, um, something that works for somebody might not work for somebody else in the same situation. And one thing that comes up quite a bit that people either ask about or they say, I have a trust, so my assets are protected if I have to go to a nursing home. And this is one of the things that might not be wrong. It might be correct, but it depends. It depends on what type of trust it is, and it depends on some other factors. A lot of times when people say, I have a trust, they're talking about a revocable trust. And that type of trust does not provide any type of asset protection or protection from the cost of nursing home care. That is a type of trust that is mainly done more for probate avoidance, for some more flexibility in planning. I'll talk about that in a little bit. It is not a trust where somebody is giving up control or access to their assets. The person who creates the trust, or we call it the settlor, as the beneficiary of the trust. They're a lot of times typically the trustee of the trust, meaning they control the trust, and they can take all the money out of the trust if they want to with no restriction. And they can change the trust with no restriction. This is different than an
Yeah.
irrevocable trust. And in an irrevocable trust situation, that type of trust may protect an individual's or what used to be an individual's assets from the cost of nursing home care. But again, it kind of depends on certain factors. One factor might be the length of time that it's been since the trust was created or the assets were put into the trust. If this is trying to be done for Medicaid planning, Medicaid is a 5-year look back period. And so certain things take 5 years to work. And so it may depend at what point in time we're at in that timeline. Typically, the settlor is not going to be the beneficiary of an irrevocable trust, although there are some exceptions. You can create what's called an income only trust. And that is a type of trust where the settlor does get the income from the trust, but they can't get any portion of the actual assets of the trust. And there's also something called a pooled trust. And that is a special type of trust individuals can put their own assets into, and it's not a penalized transfer for Medicaid purposes, and it's not considered a resource of theirs for the cost of nursing home care, but it is limited in what it can be used for. And the biggest trade off is that it has to have a payback to the state of Ohio for any Medicaid benefits that the individual receives during their lifetime. So typically, with an irrevocable trust, the settlor is either not a beneficiary or it's very limited. They can't just withdraw money without restriction. They can't change what the trust says. And in that case, we may have a situation where assets are protected from the cost of nursing home care, but it's not that every type of trust that somebody creates protects their assets from the cost of nursing home care. And that sometimes is can be confusing to people, or they hear, trust, and they think that's going to have some protections that it might not because it's of what type of trust it is. Another thing that comes up quite a bit, or I hear pretty often, is individuals thinking that they don't have enough money to create a trust. That a trust, that you have to have X number of dollars in order to create a trust, or trusts are only for tax planning for the ultra wealthy, and that's not the case at all. There may be some situations where an individual's resources really are very limited, and so maybe a trust doesn't make sense for them. That I would think that their assets would have to be pretty low. A trust can be a little more expensive on the front end, but it avoids expense on the back end, and it can be a very helpful thing for a variety of reasons. And you do have, those trusts that you might have wealthy individuals that create for um, asset protection. In Ohio, you can create uh, a trust that you're a beneficiary of for your own asset protection, but you have to give up a lot of control to do that. And typically, that doesn't make sense unless an individual has a lot of assets or, tax deferral or minimization. Again, those are for the wealthier individuals. But for individuals who might not have a taxable estate or who might not be concerned about asset protection, there's still benefits to creating, and I'm talking really more about the revocable trusts that I just mentioned, to creating a trust for probate avoidance. There's other ways to avoid probate without using a trust, but they make things typically a little bit more difficult from an administrative standpoint. If somebody has one child, that's pretty easy. They can, spouses can avoid probate pretty easily by just making everything joint. One child, you can name that one child as a beneficiary. But, let's say you have four children and everything gets divided up all on beneficiary designations into four separate shares. There's expenses to be paid when somebody passes away, maybe house expenses before it gets sold or funeral expenses. And then if everything's divided up, there's no pot of money there to pay for things. And, you know, a child or other beneficiary is stuck going to the other beneficiaries saying, "Hey, I paid these expenses, now you should give me your share of what I paid." And that might not go so well. Having the trust funnels everything into one pot, and expenses can get paid out of there before everything gets divided up separately. Um, and, also keeps it out of probate as well. A trust also can give someone more flexibility in how they want to leave assets to their beneficiaries. They might have minor beneficiaries or beneficiaries who have special needs and they're receiving maybe Medicaid benefits or other types of government benefits. And, or they might just have somebody who's a spendthrift or has drug or alcohol problems and reasons why they may want to keep somebody's share in a trust. And doing that in a standalone trust outside of a will and outside of probate keeps things much more simple. The court is not overseeing everything and forcing that trustee to have to account to the court. There's much less red tape that way, and it still avoids probate. Um, Probate is just the process of getting something transferred that an individual owned and didn't have a beneficiary or a joint owner or a trust so that it transferred automatically. It's basically the procedure for getting somebody appointed with authority to transfer the assets where they need to go. And a will only applies to things that go through probate. And that's often misunderstood as well. Somebody might have a will that says, I give $5,000 to my church, and then I split the rest between my two children. And then they go and they put beneficiaries on all of their accounts, naming their two children. That means that if nothing passes through the will, the church isn't going to get that $5,000. So things only pass under the will if they go through probate. So if somebody has kind of a different, unique way they want to distribute things, or they have some specific charitable gifts or things like that, that's hard to do with just beneficiary designations on everything. And so a trust can be helpful for things like that. And it doesn't matter how much money somebody has, for a trust to make sense. It typically in those scenarios is going to make sense. You don't have to have, hundreds of thousands of dollars or millions of dollars to create a trust. The next category of things I want to talk about are within the powers of attorney. These are another kind of document that can be sort of misunderstood, or people don't necessarily always understand their importance. A lot of times people think I don't need a power of attorney yet. And because I'm able to handle my own finances, I'm able to do things for myself. And I often explain to those people that I have a power of attorney, that names my husband. And um, it's actually, it's immediately effective now. That's typically how we recommend doing powers of attorney for property or finances. You can create a power of attorney for finances that doesn't become effective until you become incapacitated. But in order to do that, you have to build in some provisions into the power of attorney document that have to be proven before the individual you're naming can act. And in my experience, banks already or financial institutions are already kind of skeptical of powers of attorney. They don't always like to accept them. And in Ohio, they're not required to accept power of attorney. And so putting extra things in the document that they need to satisfy themselves have been proven before they can let the individual act puts more liability on them. And I feel that it would be more difficult to get a bank to accept that type of power of attorney. So at our firm, I think I've only done maybe one springing power of attorney. We almost always do them as being immediately effective. And, it's important to trust the individual that you're naming that they're not going to act until you need them to. But before you need a power of attorney is exactly the point in time that you want to put a power of attorney in place. There's two different kind of categories or types of powers of attorney. The one I was just mentioning, financial power of attorney, but also healthcare powers of attorney. In Ohio, healthcare powers of attorney are always those springing documents. They don't become effective until you're not able to make your own healthcare decisions. Um, but you definitely want to put these documents in place when you have the ability to still do so, to still sign, and to make a decision for yourself about who you want to make decisions for you. Without a power of attorney, somebody has to go to the court and apply to be a guardian to make financial or healthcare decisions for somebody. And that is an involuntary um, action or involuntary procedure that, unlike a power of attorney, takes away your ability to also still act. If you have a power of attorney, that doesn't mean you can't still access your bank accounts. You still can. Just means that the person that you're naming also has the authority to act for you. But a guardianship completely takes away your ability to act for yourself. And the court is appointing somebody to make decisions for you as opposed to you making the decision in your power of attorney who you want to handle things. A power of attorney also keeps things private, whereas a guardianship is public record in the probate court. There's also probate court oversight of a guardianship, and a power of attorney does not have that court oversight, and it's much easier to act. With a guardianship for property or finances, the guardian has to go to the court and ask permission to pay for anything. They have to inventory all of your assets to the court. They have to do annual accountings. And it's very, very cumbersome. And so, in some circumstances, a guardianship could still be necessary, but almost always having a power of attorney is going to avoid the need to have a guardian appointed for you. And in most situations, that's much more preferable to a guardianship. Another one that happens very, very often is that somebody thinks that because they need son or daughter or whomever to help them pay their bills, that they should make them a joint owner on any of their bank accounts or on that checking account that they're paying bills out of. Sometimes this isn't a huge deal, but a lot of times this does actually mess with people's estate plans and the way they have things set up. So I was talking about before how everything, if you have a joint owner or a beneficiary designation, then those things don't pass through probate and your will does not control them. So a lot of times, people will just put their son or daughter or person who's helping them pay bills as a joint owner on their bank account when what they really have is their estate plan splits everything among three people. And they don't really intend for the person who's on their bank account to get the money in the account. They just want that person to help pay the bills, and then they want that money still split with everything else. And sometimes this works out. The person understands that they get along with the other beneficiaries and they share the money. And other times it's a fight and they're saying, I was supposed to have this money, and the other beneficiaries are saying, no, that was just for convenience purposes to help pay bills, and it's supposed to be split with everybody. So this really can create a mess. And a lot of times the banks will tell people that this is how they want to set it up. You want a joint owner. But a lot of times what you really want is just somebody to be a signer. Having somebody as a signer on your account doesn't avoid probate, but it helps that person be able to help you pay your bills without making them a joint owner. They can use the power of attorney to do this and have the bank put them on as a signer. Um, it just doesn't always happen that way, and it can cause some real problems. And then as far as probate avoidance, at that point, you could still put, a beneficiary designation or something on that bank account to also avoid having to probate it. But typically, if you've got a situation, in some situations, somebody actually does want the individual that they're naming as the joint owner to have that money as well. So if that's the case, then that's different. But if they really want that money to be treated the same way as everything else under their estate plan, then adding a joint owner is not the way to go about that. They would want to have a power of attorney and have that person added on as an authorized signer. I'm going to spend the most time talking about Medicaid planning and a little bit about special needs planning at the end. Um, this is one of the more complex areas, and a lot of confusion can come about within this because of how complex the rules are. And so often we hear people saying, "Oh, well, my neighbor, did this for her grandmother, and it worked out great." And it's not the thing that they need in their situation at all. So it's very fact specific, and there can be a lot of kind of misconceptions and things in this area. One of the biggest ones I hear all the time, almost every time I'm meeting with somebody to talk about even estate planning, and then some long-term care planning concerns come up, is if I have to go to a nursing home, they will take my house. I think sometimes by they mean the nursing home. Sometimes I think they do mean the state. And it's not that simplistic that, and not everybody who goes into a nursing home, you know, they're not going to come take the house. If somebody's on Medicaid and, to kind of understand how Medicaid works, it'll be good to look at the eligibility components of Medicaid. But um, there are situations where there can be Medicaid estate recovery after somebody passes away, and the state may look to be paid back for the benefits that they advanced or paid during the person's lifetime. But they can only go after assets that were in the Medicaid recipient's name when they passed away. Um, so I'm going to take a step back here and just talk first about the financial eligibility requirements for Medicaid. You, of course, have to have uh, medical eligibility for Medicaid. Um, if somebody's in the nursing home, they pretty clearly qualify for that. But there's also financial eligibility components for Medicaid. If an individual's income is below a certain amount and their resources are below a certain amount, and they haven't made any transfers that are considered improper or gifts during the 5 years leading up to their Medicaid application, then they can receive Medicaid benefits to pay for the cost of their nursing home care. There's also an ability to get some Medicaid benefits at home through the Passport Waiver Program. And there's also a waiver program for assisted living. And each operates a little bit differently, but your financial eligibility requirements are the same. In Ohio, it's what's called an income cap state. And so they do look at your income and an individual's income has to be below the current amount is $2,523 a month. If it's not, there's this actually a special type of trust called a qualifying income trust or QIT that an individual can funnel their excess income through. And it's really a silly thing. It doesn't make a whole lot of sense to me, but basically the excess income goes in, it comes back out to pay the approved expenses like medical expenses, and that person's then immediately eligible for Medicaid from an income standpoint. So having income above that cap doesn't necessarily mean you're not going to be eligible, but you need to put this special type of trust in place. Uh, The individual's resources for a single individual, if they are at home or they have the intent to return home, the house will be exempt. Um, the intent to return home buys us a little bit of time when we're dealing with a single individual who needs to sell their home. Most people who are in a facility do have an intent to return home if they can, um, but the Medicaid caseworkers typically aren't going to accept that for forever. And you do want to deal with assets like the home and things because the exempt, even though they're exempt resources during lifetime, I mentioned Medicaid estate recovery can come back on those items when the person passes away. Um, so the house is exempt, but we're typically going to try to do something with that. The car is one car is exempt and $2,000. So they can't have more than $2,000 of resources. For a married couple, the Medicaid recipient can still only have $2,000, but the house is exempt for the spouse. So if the spouse is living in the home, um, the house is exempt. If there's a spouse, there can't be any Medicaid estate recovery until the spouse has passed away. And even then, only on assets that had been in the Medicaid recipient's name when they died. Um, and if the spouse is living in the home, Medicaid also cannot put a lien on the home. So there's protections there, and there's very limited circumstances really where they can come in and they can take the home or put a lien on the home. Um, and with the state recovery, they don't really come and take anything. They just, they may put a lien on it or they send a letter saying this is the claim, this is how much is owed, and then, the family sells the house and they would have to pay back the claim. There are circumstances where there's still equity in the home and the family gets to keep that. So they don't just take the house. That's a kind of simplified um thinking of how it works. But it is, a valid concern of individuals and wanting to try to preserve the value of the home or try to preserve some assets is certainly valid, and we help people do that quite a bit. The so in addition to the house and the car, the spouse can also keep one half of the countable resources. So that's everything that's not exempt, but only up to a maximum of 137,400. That's what's called the community spouse resource allowance, and it is determined as of what's called a snapshot date. A snapshot date for typically is the first day that the Medicaid recipient spouse is in the nursing home. Technically, you can have an earlier snapshot where one of the spouses was in the hospital, for example, and then rehab for more than 30 days. Um, and technically, you only ever have one snapshot. But how this typically comes up is that it is the date that the spouse goes into the nursing home. It operates a little bit differently for the passport waiver at home and the assisted living waiver. That there it is the first day that the um, medical eligibility requirements are met and the services are applied for, because there the person's not going into a medical facility. Medicaid actually doesn't consider assisted living a medical facility. So for at-home care or assisted living, the snapshot does not occur until the services are applied for and the medical eligibility requirements are met. There is a minimum amount that they won't let the spouse go below, which is $27,480. So they do put a minimum amount that the spouse can keep on that as well. Um, the spouses have, or the well spouse or community spouse, the spouse that remains at home, has a year to get the Medicaid spouse's name off of assets and into their name, which you absolutely want to do because of the Medicaid estate recovery. And again, they can only go after things that are in the Medicaid recipient spouse's name when they pass away. So if the house gets transferred to the spouse before the Medicaid recipient spouse passes away, then unless the that other spouse later needs Medicaid, the house is protected there. They can't, just because the one spouse was on Medicaid, they can't come and take the house. Um, so that those are the main points for married couples for the house. Just to kind of, I apologize, I know I'm throwing a lot at everybody here. Um, the 5-year look back period, the way that if you did make transfers during the 5-year look back period, the way that that works as far as the penalty is that they take the amount that was gifted and they divide it by what's called a penalty divisor. Currently, that amount is $6,905. And they determine how many months of ineligibility there would be because of the transfer. Um, the penalty doesn't start to run until the individual has actually applied for Medicaid and they are eligible but for the gift, meaning that they're down to $2,000. So it's very, very important that if there is gifting that's done, and I'm going to talk about some planning techniques in a bit, but if there is gifting done and you're not intentionally triggering a penalty, which we do sometimes, we just have to make sure there's some exempt monies to pay during the penalty period. If you're not trying to do that, you need to wait until the 5 years has run before you apply for Medicaid, because the penalty will be triggered upon the application being filed, and it could be many, many months, and the person only has $2,000 left. And if you don't have a plan for covering during that penalty period, that can be a huge problem. That kind of gets us into this next point that because of that 5-year look back period, and people always hear about that, you need 5 years, you need 5 years. They think that if they didn't do anything 5 years ago or more than 5 years ago, that there's nothing that they can do at that point. But we do a fair amount of what I call crisis planning, where somebody needs to go into the nursing home, and we are still able to preserve some funds. Um, there are different stages of planning, and of course, the more advanced planning that you do, the more you're able to protect. But that doesn't mean that just because you didn't do advanced planning, you can't protect anything. And we do have situations where people come in, and we're more in that first stage, that Medicaid pre-plan stage. Um, they might be younger individuals. They're in their, 60s or 70s, and they're healthy. And, we talk about the types of things that would need to be done to get Medicaid eligibility, which typically is giving away most of your money. And they're really not prepared to do that. And I typically would say in that case, it's premature to do something like that. Or we get individuals who have limited resources. And if something were to happen to them during the next 5 years, they wouldn't have enough funds to cover the cost of their care. But they're also not at a point where they need care now, and we can't trigger a penalty period. In those cases, we typically recommend not doing any transfers at the time, and we just do a pre plan. We make sure that the powers of attorney are in place, which is very important. There are certain powers that need to be expressly granted in a power of attorney document in order for the individual that you're naming to be able to exercise those powers. And they're exactly the types of things that we need to do when we're doing long term care planning. Things like creating a trust, gifting, changing beneficiary designations. And so, if an individual is on board with the idea of Medicaid planning, but they're not ready to do it yet, they should have these powers in place so that if down the road they're at a point where they're not able to do them for themselves, the individual that they're naming can do those things, create a trust, do gifting. Um, Trusts could be very important, just like for that qualifying income trust that I mentioned. If the person's income is over the income cap, having somebody be able to do that with the power of attorney can be very important. Um, Also, just looking at general estate planning documents at that point and making sure that things are in order. Um, Maybe, just the will needs to be updated. Maybe they should do just a regular revocable trust. Just kind of, at that point, we look at the just general estate planning documents. Um, there may be an individual that they do need a little bit of care right now, but not, nursing home level care. And so they've got maybe one of their children, for example, helping do things for them. And if they have a written agreement with that child to pay them, and the trade-off is that it's taxable compensation to the caregiver, but those payments won't be treated as gifts for Medicaid purposes down the road. Again, provided that the agreement is in writing, the terms do need to be like a reasonable hourly rate to the caregiver. The caregiver should keep a log of what they're doing. But that is something that an individual might want to get put in place during the pre-planning stage. In the right situation, if somebody has a child who is willing and able to move in with them, this could be another way to protect the house. If the child is there for 2 years or more and they are providing care to the parent, and a doctor will sign off that the child's presence in the home kept the parent out of a nursing home, there is an exception in the law to allow the house to be transferred to that caretaker child without a penalty for Medicaid purposes. And so that can be another a way to try to protect the home without it being a gift. These are things that may be considered in the advanced planning stage as well. But at that point, maybe if you're doing a 5-year plan, that would be where you're actually gifting some assets away to, we typically use an irrevocable trust, especially when it's large amounts or if it's the house. And then you wait out the 5-year period. So doing this involves creating a budget. We try to estimate, it's never perfect. No one has a crystal ball to know, how what might happen in the next 5 years. But we try to figure out what we think the individual might need to keep in their name for 5 years, and then they gift the balance. And this is typically done where you think that nursing home care is a real possibility at the end of that 5-year period. You can do, I kind of call that an all or nothing plan. It doesn't have to be all or nothing. It could be, extra money. If somebody has, let's say, $200,000, for example, that they don't think they're ever going to touch. Um, that is a situation where they could gift just that 200,000. They're not going to probably be immediately eligible for Medicaid at the end of the 5-year period, but after 5 years, that $200,000 would be off the table for Medicaid purposes. So there's options there for the advanced planning that don't necessarily involve giving away everything. But even if you don't have that 5 years, and this is where we're in the crisis plan situation, there are things that can be done. Um, when you've got a married couple, converting their countable assets into exempt assets can actually be really helpful technique. You can actually have the spouse keep more than their community spouse resource allowance, more than that 137,400 number, um, or the one half if it's less, um, by doing something like a Medicaid compliant annuity. This is where you take some of their assets and you put it into an annuity that is an exempt resource for Medicaid purposes. That has to be set up a certain way. The state of Ohio actually has to be the beneficiary, and it has to be actuarially sound for the spouse's life expectancy, but it can be shorter than the spouse's life expectancy. So even though the state of Ohio has to be named as the beneficiary, the payments can be such that they come out in a year or 2 years, and the spouse then gets to keep those amounts that come out of the annuity in addition to their resource allowance. So that's one thing that can be done, but converting countable assets to exempt assets typically works better when you've got a married couple, or you can do things like, prepaid funerals, things that aren't gonna remain in the person's name when they pass away that would be subject to estate recovery. But irrevocable prepaid funeral contracts are another exempt resource for Medicaid purposes. I mentioned earlier the pooled trust, that special type of trust that an individual can put their own money into and not be penalized for Medicaid purposes. If you've got a small amount, relatively small amount that you're dealing with, let's say you're down to $10,000 and you just want the immediate Medicaid eligibility, you could put $10,000 in this pooled trust. It can be used for things during the Medicaid recipient's lifetime. It's just that if anything's left in it when they pass away, it has to go back to the state of Ohio. And so we don't typically dump a lot of money into pooled trusts. We do use them on that third bullet point there when we do the crisis plans to try to preserve some funds. And in this situation, it depends on what the individual's income is and what their cost of their care is, but we typically are able to protect about half of what they have. We do that by making the family makes a gift of one half of what's approximately of what the individual has and puts the other one half into the pooled trust. The gifted portion triggers a penalty, but we're applying at this point and we're triggering that penalty because we have the pooled trust over here as an exempt resource that is going to pay the nursing home bill during the penalty period. So that is one way that we can if somebody doesn't have 5 years, we can make that work. Typically, the longer the penalty period, the less that makes sense and the more it would make sense to just do a 5-year plan. You can still do a 5-year plan in a crisis situation. It's just that sometimes people feel that their expected life expectancy at that point is not 5 years. Maybe they just don't feel that it makes sense. There's enough money to cover um, and presumably have something left over, and they don't think that a 5-year plan, makes sense at that point. So, um, but there are things that can be done, and the 5 years is not a roadblock necessarily to doing planning. Um, I touched on this a little bit under the Medicaid eligibility discussion, but there are protections for the spouse who remains at home, the community spouse or the well spouse. So a lot of times people think if I have to go to the nursing home, my spouse won't have anything to live on. Um, and Medicaid does have protections in the law to prevent just that. They don't want to see the spouse become impoverished. And, in a lot of cases, it's not as much money as the individuals had before, or it's not what you would consider a lot of money, but it is something. And there are some other protections I haven't mentioned yet dealing with income. The community spouse is always allowed to keep all of their own income. The Medicaid spouse gets to keep $50 of their own income. They can also pay the spouse's um, health insurance premiums, including the Medicare premium. And then the balance goes to the nursing home unless the community spouse needs some of the Medicaid recipient spouse's income to bring their income up to what's called the minimum monthly maintenance needs allowance. That minimum amount is currently $2,177.50. So if the community spouse's own income is below that, they are entitled to a portion of the Medicaid recipient spouse's income to bring them up to that minimum. There is an ability potentially to get up to a maximum amount, which is $3,435. And that is if the spouse at home has shelter expenses that exceed an amount that's referred to as the excess shelter standard. That's currently $653.25. If the monthly shelter expenses exceed that amount, then the spouse can get an additional portion of the income to bring them up to the maximum, or a little bit below that, depending on what the excess is. Um, to calculate that amount for utility purposes, there is a standard utility allowance that is used. That's $580. So basically, there's a complicated formula, but um, there are circumstances where, in addition to the resources that the spouse is allowed to keep, they may be able to also get a portion of the Medicaid spouse's income. And anything that doesn't then go to the spouse is paid to the nursing home. This kind of goes along with I hear this probably about as much as I hear that the concern that the house is going to be taken. That the house should be, I should put my house in my kids' names in case I have to go to the nursing home. This is another one that depends. This might make a lot of sense, to transfer the house, but I always get really nervous when people just call up and they say, "I want to put my house in my kid's name." And you have to get them to step back and tell you, okay, what else do you have? What other resources do you have? And you explain how, the penalty works and the 5 years works, and if they would need care in the next 5 years, would they have enough resources to cover any kind of penalty period from gifting the house? It typically doesn't make sense to do this unless you're doing it as part of a comprehensive plan. You're looking at all everything, all of the assets, and you're thinking about, because just transferring the house isn't going to get somebody eligible for Medicaid if that's what they're trying to do, if they've got, $100,000 of other monies. But $100,000 of other monies is also not enough to pay for, a few years of nursing home care if they don't make it through 5 years. So it's good to have a conversation about this before it's just done. Um, I think sometimes, I have seen situations where it is just done and it works out. They make it through the 5 years and everything's fine. But I just don't think people don't understand the repercussions potentially of doing this, and doing it in a vacuum can be dangerous. Um, I also don't typically recommend that the house just get put in the children's individual names. Um, we, as I mentioned earlier, typically recommend using an irrevocable trust when we do any type of large gifting or gifting of the house, for two reasons. One, some tax benefits can be built into the trust to minimize capital gains if the house is sold, either during the transferor's lifetime or after their death. And two, the irrevocable trust protects the trust assets against bad things that can happen to the trustee or the beneficiaries. Somebody can get sued. If somebody passes away, the trust says what happens, somebody else can step in, to manage things, and it says what happens, to what would have been that beneficiary's share of the trust. Um, what if one of the beneficiaries gets divorced? The trust insulates that from their personal assets and protects it if anything bad would happen to, the beneficiaries. The last thing that you want is you transfer your house to your child, and then they get into a bad car accident, for example, and they're getting sued. And the house that you're still living in is now, potentially going to get, taken away by creditors. So this can actually, backfire from what people are really trying to do. They're trying to protect the home. So I do strongly encourage putting the house in an irrevocable trust if this type of planning is going to be done. And a lot of times, and it makes sense, people think that, they should reserve a right to stay in the home. If I do transfer my house, I should reserve a life estate or right to live there for my lifetime. This can also muck things up as far as Medicaid planning. It used to be that this type of planning was done. It was, that life estates were used as a planning technique, and they were exempt. And then the law changed, I believe, in 2005, and Medicaid puts a value on a life estate or a right to continue to live in one's home. And the value, the table that they use to put a value on the home, it's really um, ridiculous. I was just looking at the table the other day for somebody. I have a situation where years ago they transferred the home and kept a life estate, and now there's a need for Medicaid, and we have to deal with this life estate. The person is 96 years old, and the table says they have a 22% interest in the home. Um, Obviously, a 96-year-old doesn't have 22% of their life left. So this really, it doesn't make a whole lot of sense, the table that they use. And people often don't realize that just having this right to continue to live in the home is actually an asset for Medicaid purposes. Um, so what we typically do, and we do this for other reasons as well, but we have a lease in place, and the lease is between the person who transferred the house and the recipient. So typically, when we're doing this, the irrevocable trust, and the person who transferred the home and still is living there pays rent. We figure out the amount of what the expenses were that they were paying, and typically they pay that amount. So what was the amount of the property taxes, property insurance, and they pay a rent amount equal to that. And then we build into that lease some automatic renewal periods. So it might say it's for a 5-year term, and it has, 2 or 3 more automatic 5-year renewals. And that's meant to kind of try to get them through what we anticipate maybe their life expectancy, without saying they have it's for their lifetime or having the right to live there, because that could be construed as life estate. Um, so this is lastly the one point I wanted to make about special needs planning. And this is something that I hear people say very commonly, or they think, or I see plans where they've done this. Um, they think I should cut out my child with special needs and give his or her share to a sibling who will take care of him or her. And everybody is well intentioned when they're doing this. I'm sure that the other child or other beneficiary who's going to be entrusted with the monies has every intention of using them for their sibling or for the person with special needs. And the parents are doing this because they're trying to make sure that their child, if they're on government benefits, they don't lose those benefits from receiving their inheritance. But bad bad things can happen. That's out of that person's control. They can get sued if they pass away. And they're married, it's probably going to go to their spouse. Does the spouse feel the same, obligation to take care of their um, brother or sister-in-law or this other beneficiary with that money? So it can go to other individuals who they weren't part of the original plan, and they don't have any intention of helping take care of this person with special needs, and they're left with just their benefits and nothing to really supplement that or pay for things for them to make their life more enjoyable. And in Ohio, there's a very, very easy way to do this without having to cut the child out. And it's called a wholly discretionary trust. And you can leave the share for the individual with special needs in this type of trust. It's written in such a way that the person who is in charge, the trustee, does not have to give them any of the money at all. So you do want to pick somebody that you trust is going to be reasonable and is going to use the money for the person with special needs. But because the person with special needs cannot force the trustee to give them any of the money in the trust, it does not jeopardize their eligibility for any means tested government benefits. Meaning they look at your income and your resources. So if they can only have $2,000, if they inherit money in a wholly discretionary trust that has $300,000 in it, that's okay. That's not counted as their resource, and it's not going to jeopardize their benefits. There can be situations too where the parents or the person creating the trust thinks that the benefits that the individual is receiving are means tested, but they're actually not. So an individual could be receiving supplemental security income or SSI. That is when an individual is disabled and they have not worked enough quarters to receive Social Security disability. SSI is means tested, Social Security disability or SSD is not. And they only, for SSD purposes, they only care about your earned income or your ability to be employed and work in any job. If you aren't getting earned income, no other income or resources are going to impact your SSD. For SSI, however, income will impact that, and you can only have $2,000. And you also, if you receive SSI, receive Medicaid, and for Medicaid, you can only have $2,000. So definitely in those situations, a wholly discretionary trust does make a lot of sense. An individual who's receiving SSD after 2 years will receive Medicare, but that is also not means tested. Medicare is what every individual who's over the age of 65 or who has been receiving SSD for 2 years receives for purposes of their um, health benefits. A person can actually be on all four of these benefits. If you don't have a SSD in an amount equal to the maximum benefit for SSI, you can also get SSI. So somebody can be what's called a dual eligible. They're receiving both SSI and SSD, and they're receiving both Medicaid and Medicare. Um, so sometimes you just don't know what benefits people are on, and the safe thing to do is to use the wholly discretionary trust. And the wholly discretionary trust can also be beneficial for other reasons. Sometimes individuals with special needs just need that oversight for other reasons. Um, so using that type of trust in a special needs planning situation is typically preferable. And that is a third party trust, not a first party trust like the pool trust. The wholly discretionary trust does not have to have a payback provision in it. So that's another thing that comes up that sometimes is confusing for people. They think that you have to have a payback for a trust that you're creating for somebody else's benefit, and you're not the one receiving the Medicaid benefits. It does not have to have a payback to the state. So that is everything I have there. I'm going to stop sharing.